Hi, good afternoon. My name is Ebony Howard. I'm the Deputy Director with the National Juvenile Defender Center. Thank you so much and welcome. I just want to start off with a couple of remarks before we get into our awesome speakers today. I just want to start off by talking about how children of color, particularly Black and Latinx children, face insurmountable obstacles in the juvenile justice system. In 2018, Black youth comprise approximately 16% of kids in the United States between ages 10 and 17. But they accounted for 35% of juvenile arrests, 40% of detained youth, 39% of youth formally processed to the juvenile court, 37% of youth adjudicated, and 51% of youth waived to criminal court. Now, we know that these disparities are not because kids of color engage in more negative behavior than other children. Study after study has shown that youth engage in the same type of risky behavior that is characteristic of adolescents, regardless of their ethnicity or of their class. The truth is that racism that is woven into the American justice system and the racial biases that court stakeholders have, like we all have, those two things work together to subject young people of color to harsher treatment compared to white kids. Today, we have two phenomenal people who are going to lead us through a discussion that explores the dynamics of this racial climate that's in our school system. This discussion won't be theoretical. Rather, the contours of today's talk will be the lived experiences of children who are forced to navigate the complexities of a biased system while their bodies continue the process of adolescent development. Leading us through this journey will be Professors Henning and Geoff Ward. Professor Henning is the Bloom Professor of Law and Director of the Juvenile Justice Clinic and Initiative at Georgetown Law, where she supervises law students and represents youth accused of delinquency in the DC Superior Court. Professor Henning served as Georgetown Law's Associate Dean for Clinics and Experiential Learning from 2017 to 2020. Professor Henning writes extensively about race, adolescence, and policing. She also has a forthcoming book, The Rage of Innocence: How America Criminalizes Black Youth. Professor Henning is a nationally recognized trainer and consultant on the intersection of race, adolescence, and policing. Professor Ward is a professor of African and African American Studies and faculty affiliate in the Department of Sociology and American Culture Studies program at Washington University in St. Louis. His scholarship examines the racial politics of social control and the pursuit of racial justice, historically and today. He is the author of The Black Child Savers: Racial Democracy and Juvenile Justice. This is an award-winning book on the rise, fall, and haunting remnants of Jim Crow juvenile justice. Now, before I turn you over to our wonderful guest today to have a discussion about reconsidering how race operates within our justice system, I just want to ask one thing of you. Please listen to this discussion with an open heart and with a mind towards serving our children. For our judges who are here today, know that the children that you serve in your courts are fundamentally no different than the youth that are in your private lives. A child that appears before you is the same as your son or daughter, your niece or nephew, your grandson or granddaughter. The children who are in the court system, they're our children. So without further ado, I give you Professor Hennings and Ward.
Excellent. Thank you so much, Ebony, and to all of the National Juvenile Defender Center for inviting us into this space and to participate in this very important conversation about race, and what it means for the work that we do on behalf of children in the juvenile legal system. So let me say to you, Ebony, and to the judges and all of the other participants today, that we really want to ground this conversation in the real lived experiences of Black and Brown children who appear in juvenile courts across the country. We also want to make sure that this conversation is directly relevant to the law and the practice, the juvenile and criminal law and practice. This is not just about history, data, and research, all of which are important in their own right, but this is also about how each of those, the history, the data, and the research, affect the everyday activity of the courts. So the way we thought we would bring this conversation to life is to work through a series of vignettes. And these will be vignettes involving children who have been directly impacted by the legal system. And we will use those vignettes to explain how structural racism operates and how it impacts the children that we serve. And most important, we want to use these vignettes to talk to you as judges and other practitioners about what you can do, about what you can do to account for structural racism in your own analysis and your own decision-making in your cases. So I'm going to jump right in. And what's going to happen is Professor Ward and I'm going to share the vignette with Professor Ward, and he and I are going to go back and forth in an exchange. So you all ready, Professor Ward? Excellent. All right, so here's our first vignette to really set this up. So I'm going to talk about Andre. So Andre was a 15-year-old Black boy who was walking down the street with a friend. His friend's name is James. There was no report of crime. The boys weren't doing anything out of the ordinary. The police acknowledged in subsequent testimony that the boys weren't being loud, they weren't smoking, they weren't drinking, yet the police officers drove up next to them and asked them if they had heard any gunshots. When the boys said no, the police then asked them to show me your waist. Both boys complied immediately by lifting up their shirts. Unfortunately, the officers were still unsatisfied and asked the boys for permission to search them, at which point Andre and his friend said yes, and 4 uniformed officers jumped out of their car. They forced the boys against the wall and they frisked them, they patted them down. And so that's our first vignette. And as a defense attorney, I am always baffled when children agree to be searched by the police. And so I know a lot of this is about adolescent development, right? Adolescents are less experienced with their rights, they're impulsive, they don't think ahead to the pros and the cons of their decisions. But for 2 Black boys like Andre and James, this encounter is also very much about race. And Andre was actually a client of mine in Washington, DC. And when we asked him, so why would you agree to be searched? His response was, well, wouldn't you? And he said, quite frankly, they were going to frisk us anyway. And if we ran, they were just going to shoot us in the back. So Andre didn't have to say anything about race explicitly for me to understand exactly what he meant. And so, Geoff, this is where I want to draw you in. And I'd love for you to help us understand the historical context that informs how an encounter like this likely plays out in the minds of Black boys like Andre and James. What is the historical context? Tell us about how young people of color experience policing today.
Thank you, Chris, and to everyone for inviting me to be a part of this exciting conversation. I want to back up first in responding to that question and provide a little bit of context on the regarding the racial history of juvenile justice that I think is helpful to us, our discussion of this vignette. In the Black Child Savers, which is an historical and sociological analysis of the racial politics of youth justice, where I go back to the very foundations of the idea of the child and the development of the parental state and ultimately the formal juvenile justice system, I highlight a few key things. One is that the most fundamental is that the problem of unequal protection in American juvenile justice is deeply rooted in white supremacist ideology and related political structures. More specifically, this liberal rehabilitative ideal and related resources, including the idea of diminished criminal culpability for children, have been systematically withheld from Black and other non-white youth and communities in a few key ways. One is through the way that racial ideology dehumanizes. Racist ideology dehumanizes the idea that Black children are fundamentally incapable of moral and intellectual development, for example, by virtue of race. Pseudoscientific racism of the era that the juvenile justice system grows up in asserts that Black people's brains stop developing after the age of 13. And imagines, in fact, that African Americans will become extinct because of their inferiority. So this idea, these ideas gave credence to the notion that the juvenile justice system should be designed for and applied in the context of white and potentially white communities. Another key aspect of this is the denial of democratic standing, and this gets really closely to the point of this search scenario. But in general, what I'm referring to here is that this foundational idea that American juvenile justice would be a citizen-building institution was at odds with the idea that America is a white democracy. And so what we see in the early history of American juvenile justice over and over again is this assertion that African Americans and other people of color are without civil rights and not contemplated as future citizens, and therefore not entitled to the kinds of legal and political considerations this purportedly distinct system would make. The last point I want to make here, because I want to come back to it later, is that none of this would have been so consequential if white Americans had not been able to hoard political power to determine themselves what the idea and practice of juvenile justice in this country would look like. And so this issue of domination, which is fundamentally about the problem of recognition, who has standing in the political culture, whose ideas and priorities are translated into law and policy. This made racist ideology, this effectively institutionalized it. Now, all of this has been contested, of course, and so this history is really dynamic. And the book, The Black Child Savers, is fundamentally about generations of Black women leaders in particular who worked to dismantle the resulting Jim Crow juvenile justice system. But it's interesting to have that background in mind in responding to the initial part of the vignette, where you note that that the legal system is routinely forsaking the rights of Black and brown children in favor of a perception of public safety. And this is a scenario where, in the contemporary period, where this forsaking of rights is rationalized on the basis of a notion of public safety, but there has always been this forsaking of rights for various reasons. And to get directly to your question about why the youth would consent here, or seemingly consent, is this history of forsaken rights is well known to communities over generations. Legal and racial socialization are primary carriers of historical trauma, of public memory. Many of the folks in the audience will have heard about, and many of them will probably also have engaged in what has been called colloquially the talk. the talk that Black parents have with their Black children about the need for hypervigilance in the context of police encounters, because they cannot take for granted that their rights will be respected, that their human and civil rights will be respected. And parents realizing that the risks are grave, prepare children at very young ages. I mean, I've already had this conversation with my children, my two sons who are 7 and 9 years old. We've already begun to have this kind of conversation because we know that the stakes are so high and that a misstep can be tremendously costly. So I think the young people in this vignette, in this scenario, are not thinking, you know, what are my constitutional rights in this moment? And what does that entitle me to do? They are thinking, as the vignette, they're thinking that if they do not, if they are perceived as a threat, they might suffer violence and even death at the hands of the police. So, you know, I guess as a, you know, I want to push this back to you now and ask, given the complex story here, the complex backdrop here, the sort of that is driving this encounter, I wonder how, you know, as a sociologist, historian, I can sort of make sense of these analytically and write about them, but I wonder how this gets articulated in the context of law and how an argument might be made in court regarding this vignette.
Yeah, I mean, you know, this is so critical what you've added here, this notion, I love your phrase, the history of the forsaking of rights of Black and brown children is well known, and it's well known by the kids themselves. And, you know, you reference the talk as a parent, and then add on to that the contemporary access to TV, the internet, social media, where we see these images of police brutality playing out, day, after day, and that a young person of color just cannot miss that. So as a lawyer, I am increasingly reflecting on how this racial history, contemporary and, historical, intersects with legal analysis. We see structural racism in the way that laws are written, the way laws are interpreted, the way laws are implied. And so this question about, so how do I incorporate that into a legal argument? I think the encounter, I think we would all agree that the encounter between Andre and the police officers is a basic question of voluntariness in the law. Right? So that the Supreme Court has said in Bustamante, for example, that consent is valid, right? So this Andre's consent and James's consent is valid under the Fourth Amendment if it is freely given and not the product of express or implied coercion. And I think, listening to you, I think we often in juvenile court and in criminal courts, a traditional analysis of voluntariness would include factors like use of physical force, threats, aggressive demeanor, and demanding language. But given what you've told us, Professor Ward, I hardly think that force or threats or even some aggressive language is necessary for a young Black child to believe that he or she has no choice, that he or she has to consent to what is being requested. And what's so fascinating about the language in Bustamante is that it goes even further to tell us that the consent analysis not only involves some objective, reasonable person evaluation of the facts and circumstances, but it actually has language that invites a subjective inquiry that would take into account personal experiences that drive fears and motivate people to act. In fact, that's a quote from the case, right? It requires us to consider the possibly vulnerable subjective state of the person who consents. And so I think what you've told us today, this history and the talk and our understanding of that really is relevant to these types of legal questions. And I think it's just hard to disagree with the premise that Black children's perception of what is voluntary is far different from what a white child believes to be voluntary. And I think that a Black child rarely, if ever, feels free to refuse an officer's request to do anything, whether that be consent, whether that be stop. And so I should note here that race is equally relevant to this question of whether or not someone has been seized for the purposes of the Fourth Amendment. The Supreme Court told us in Michigan versus Chestnut that a person is seized when police behavior would have communicated to a reasonable person that they're not free to leave. But under that scenario and under the sort of the context that you set up about the willingness of folks to forsake the rights, right, of Black and brown children, a Black child is far more likely to believe that they're not free to leave. And so I think one of the things that we want to talk about and that we need to be attentive to when we think about structural racism and how it impacts the juvenile legal system is that we have to remember if that Black and brown children are to have the same Fourth Amendment rights, meaningful access to the Fourth Amendment. So this notion you talked about, unequal protection, right? But if we want equality of protection of rights, then the law has to account for the realities of race. So let me kick back to you yet again. I would love to hear your take on this. Sort of I've given you that legal context. So from your perspective and your knowledge of how racism works in the legal system, in the juvenile legal system today, whether you think, voluntariness is a reality that we can achieve, or voluntary compliance with the police can ever truly exist for children of color. That's a hard question, but
It's a hard question, and I think it can't be answered without bringing the interaction together. The more of the human interaction into the picture. So can the police reasonably be expected to enter into relationship with a person of color that results in some kind of voluntary cooperation, and vice versa is an important part of this. But I think, I want to also just highlight here the scope of the problem, as I see it, of unequal protection. There's a lot more discussion in the political culture today of over-policing and under-protection. And I think that is excessively limited to a focus on policing, as police organizations themselves stress. Like, if we're all, if we're going to wear body cameras, why aren't school teachers and other people who are having interactions with children and so on? And I'm sympathetic to that argument to an extent, because it speaks to the ways that unequal protection, the ways it manifests beyond policing encounters or even court encounters. And I want to talk about, and then I'll work back to the question of voluntariness. But I want to talk more about the gun and public safety. This is a nation where the obsession with guns and the proliferation of guns is significantly rooted in our history as a white settler society, where guns were seen as a vital aspect of the maintenance of white dominance historically, and to some extent still today. This has a great deal to do with why there is such easy access to lethal weapons in our society. The use of guns to facilitate dispossession, historically, the seizure of land and the securing of property and so on, and to ward off perceived threats of insurrection by enslaved and otherwise marginalized, subjugated populations. Today, you see political appeals to constituencies around the right to bear arms that are, explicitly cloaked often in racial animus. The fear of the other, whether it's an immigrant or an urban youth, and so on and so forth. Now, the reason I'm bringing this up is because, of course, the actual exposure to the risk of gun violence is far greater for someone like the young African-American man in your young man in your vignette than it is for let's say rural or suburban voters who are insisting that we have lax gun control law. And in this context, where there is also reasonable doubt on the part of the young person that the state will provide, that will protect their life from the threat of violence, whether at the hands of another citizen or at the hands of a state actor, you have this young person who's decided that who may have decided, I want to hear more about the story, but who may have decided that their best chance for safety lies in the context of what we could say, we might argue, at least for some segments of our population, is a failed state or a failing state, a state that fails to provide adequately for the needs of all of its members, for the opportunities for self-realization and so on of all of its members. A young person who may calculate that their best chances lie in arming themselves so that they can protect themselves with a gun. Now, this kind of argument about this to me is really fundamental to the idea of the insight of a structural analysis of racism, and I think it is. I know it is almost impossible to articulate in a narrow way in the context of a kind of reasonableness standard in criminal law. But you asked, can youth of color who experience, I would say, you asked, who experience hypervigilant community policing voluntarily, consent? I would first of all say that the vigilance of the policing is a part of the fundamental problem here. There is a selective policing at work, policing not of the extent to which young people in our society might be able to access lethal weapons and determination to limit that access, but a surveilling of individuals who might become subject to criminal prosecution if they are found to be in possession of objects like guns and drugs and so on. So as I think about your question about voluntariness and the reality of the circumstances of a young person in the 20th and 21st century, particularly certain parts of our country, parts of my community here in St. Louis, I think it's very difficult to imagine a scenario where one could voluntarily consent with police because of the sort of complexity of this and extent of this ordeal that we find ourselves in.
Yeah. No, I'm struck by a lot of what you said. I think one of the things that I'm sort of most struck by is this, the irony of this right to bear arms, this gun debate, as juxtaposed against the hyper surveillance of Black and brown people and the implicit fears and assumptions that we make about Blackness and criminality, and especially Blackness and violence, Blackness and gun possession. profession. And so it's a daunting, proposition. And then, so think about this scenario that Andre is in, and you're getting at something, right? You almost anticipated where the story goes with Andre. So Andre became my client in this factual scenario because indeed he had a gun. Right. And so now if we, sort of tease this story out, adding that additional layer that when the officers stopped him and searched him, they found a gun. Many of us may be thinking, well, it's great that the police got that one gun off the street. Right. But again, it's buying into this notion that it is, appropriate and right to bear arms as a white male in protection of, that in furtherance of white dominance. But it is dangerous and violent and problematic to have a gun as a Black male. But here's the thing, right? So yes, it is maybe great in this scenario, given what you said about Andre is at greater risk of gun violence or being the victim of gun violence. So it's great that police got that gun off the street, but it is also equally important for us to think about the collateral consequences of, or the collateral consequences for all young people involved when that original stop was not grounded in some reasonable, articulable suspicion to believe those boys were involved in a crime in the first place. So remember, in that factual scenario, the officers in this case acknowledged in testimony that the boys weren't doing anything suspicious. And so they instead relied on this consent to search. And so again, there will be some people who will say, well, Professor Henning, getting that gun off the street outweighs these rights, right? You've been talking about rights, Professor Ward, but that outweighs the concerns about Andre's constitutional rights to privacy and his right to move about without undue police intrusion. But when we, talk about the law, and not just history and not just political debates, I really want us to resist this false binary, right? To resist this idea that we can't protect constitutional rights and public safety at the same time. And even more than that, I want us to understand that even if Andre's submission to this police search gets one gun off the street, it is not without significant cost to him, to his friend James, who didn't have a gun, as we remember, or who, as I'll let you know, didn't have a gun, or to any other Black or brown child who is watching this encounter, right, with the police, or who hears about this encounter later on. And we should all remember that every negative sort of or harmful or unlawful encounter between the police and a young person or police and adult, particularly in communities of color, is observed by or transmitted by the young people who go home and tell their friends, who tell their family, who repeat the incident at school. So there's a real harm to racial equity. There's harm to community respect for law enforcement. There's a real harm to the psychological well-being of all Black and brown youth. And I know we'll come back to that later. But for now, Professor Ward, let me ask you this. I mean, isn't it also true that there is some research showing that over-policing that you talked about, or the aggressive policing in Black and brown communities, can actually lead to more criminal or more involvement in the criminal legal system or more delinquent activity? So what is there out there on that?
There is. I guess there's recent research that shows pretty compelling evidence that that encounters with police, particularly for adolescent Black and Latino youth, have criminogenic and psychologically traumatic effects. That essentially these interactions constitute a form of strain, that psychological strain that contribute to the future likelihood of criminal legal system involvement, none of other factors that are expected to predict, for example, educational attainment, poverty, urbanization, and so on, that are associated with the likelihood of involvement in the criminal legal system. There are really a number of studies that I could mention here that have some relevance to this discussion. Another relatively recent study showed that that exposure to racial discrimination has negative health and well-being outcomes. Poor physical health outcomes, obesity, injury, asthma, poor mental health outcomes like anxiety, increased anxiety, body image anxiety, conduct disorders, depression, and so on, self-harm, like substance use, and behavioral problems, including delinquency, are associated with the experience of discrimination. So this is all, grounds for, as you're stressing, grounds for an insistence that we prioritize equal protection under law as a way of avoiding, not only because it's the fundamentally right thing to do from a legal and moral point of view, but because the evidence of the adverse consequences of discrimination are profound. And if our interest is in fact the promotion of public safety, the evidence suggests that discrimination is at odds with that, is deeply at odds with that agenda. I want to note a couple of other examples of studies that speak to this point. One is some of the earlier work on racial inequality in the juvenile justice system points out that that youth of color are not so often subject to these kind of dramatic, extreme moments of differential treatment, but rather to an accumulation of relatively subtle acts of bias that compound over time to produce gross disparities in outcomes, like disproportionate likelihood of incarceration and more severe sentencing. And so these are, this is this sort of, it's been described as this amplification effect of bias over time. And even when it's not a dramatic encounter between a police and a young person where there's a gun and so on, just subtle harassment of the sort that I was subject to routinely growing up in Los Angeles in the 1980s. Every weekend we were pulled over by police who were aggressive, hostile towards us, frequently drawn guns, and so on. Those build up what public health scholars write about as this allostatic load, this accumulated stress in the body that we know from research is incredibly harmful. The last thing I want to point out about the research evidence is more specifically about this point. These points I want to talk about in terms of historical trauma. Earlier on, I was saying that young people today and generations know the story. They know they have heard about the legal estrangement, the failure of the state to recognize and respect African Americans and other communities' legitimate interests in the rule of law. And so I'm calling this legal estrangement. This is this sort of pushing away from the legal system that is rooted, Monica Bell uses this term to describe how histories of unequal protection have estranged communities from law, and largely through a dynamic of distrust, of not believing that the state will legitimately adjudicate your grievances. And the reason I want to bring this back up now is because one of the strongest empirical relationships between historical racial violence and contemporary outcomes that's been shown over and over again is that histories of lynching, which are also related to histories of slavery and other racialized violence, but histories of lynching are strong, consistent predictors of contemporary homicide today, and particularly Black victim homicide. Black victim homicide is largely driven by the access to lethal weapons that makes a violent encounter far more likely to become lethal than were not as easy to access guns and other lethal weapons. Now, the mechanism believed to be at work here in connecting lynching historically with contemporary lethal violence in the same communities, one of the key mechanisms believed to be at work is legal estrangement, is the distrust of the state, and such that communities believe, residents in these communities believe that they must take it upon themselves to resolve their grievances or to protect themselves, as I was saying earlier, and are likely to turn to guns to do that. So we need ways. We need to be vigilant in dismantling this understanding. It's not an illusion. It's an understanding rooted in the reality of many of our communities, unfortunately. But how do we dismantle the problem of legal estrangement? I think one of obviously the key ways is to be insistent in the application of the rule of law equally, even if it means that that some or another kind of contraband will not be detected and taken off the street. And by the way, and I want to stop here, the ease of access to guns is such that it is a gross illusion to think that the police taking a gun off the street, and we do it nevertheless all the time, but the idea that taking one gun off the street is dramatically lessening the problem of gun violence in our community is absurd. We have plenty of evidence, and unfortunately, tragedies to confirm that that is an illusion. So we need other strategies, and I think a vigilance in equal protection is a big part of that answer.
Yes, this is so extraordinarily helpful. And I got to say, there are so many threads, vigorously taking notes, because there's so many threads that we could pull out of all that you just said. But one thing really resonates with me. This is a conversation with, juvenile court judges and juvenile court stakeholders. And one of the things that we have to remember is adolescence is a time when early impressions of the law and law enforcement really become fixed in our minds, right? So early negative encounters with police officers or other subtle racial, other moments of racial discrimination have a long-term effect on how young people will engage with the police today and tomorrow when they become adults. It also has an extraordinary impact on their perceptions of the fairness of and the legitimacy of law and law enforcement. So for me, I really am sort of, excited as you talk about sort of this notion of legal estrangement, right? That flows naturally. How do we break that? Well, adolescence is absolutely a critical stage at which, we need to be thinking about the long-term effects of legal estrangement. The notions of procedural justice also come to mind, right? So that there's research on the ways in which if young people don't feel like or don't believe that the system is fair, don't believe that they are have access to their rights, or that they're not heard and listened to, then it severely undermines the success of the rehabilitative potential. A young Black child is unwilling to comply and engage with the juvenile court system if he feels estranged. So for me, that's sort of a flip side of this notion of procedural justice. And so I think, the way to sort of wrap this up and maybe move us to another vignette is I think at the end of the day, for lack of better words, kids are not any safer. The police are not any safer, And the public is not any safer if we don't do the work that we need to do to dismantle structural racism. And as you sort of tied up, and to protect the rights of children, right? In all of the ways that we believe in our Constitution, our system of American democracy, like the Fourth Amendment. And I'll just say before we transition that a number of state and federal courts are slowly beginning to recognize this intersection of race. I mean, we've moved the needle on recognizing the intersection between adolescence and critical legal questions like the Fourth Amendment and the Fifth Amendment. But now we also really have to draw that link between race, adolescence, and these constitutional principles. So there are some cases, by way of example, in which federal and state courts have found that race is relevant to the seizure analysis, for example, in that Fourth Amendment context, or race is relevant to the consent to search context. And so our colleagues from the National Juvenile Defender Center will put some of those in the chat. So thank you for that. That was very helpful. I love the threads that you drew out, Professor Ward. So let's move on and talk about another scenario. And it's a scenario that, again, will help us understand how race impacts the juvenile and criminal law. And so, again, I want to use another example involving a young person that I represented in my own practice. And so let's call him Tariq. And so Tariq lives in an apartment complex in Washington, D.C. And he likes to visit his friends and family who live in the buildings that are next door. At about 10 a.m. on one Saturday morning, Tariq walked out of his building. He headed down the walkway and he turned left just as he reached the sidewalk. Just as he turned, he saw a police car with two white officers staring at him, which caused him to hesitate and created the slightest break in his stride, which the officers described as a stutter step. The police officers then followed him in their cruiser. They pulled up on a curb, they jumped out, and they followed him on foot as he continued to walk away. And so instinctively, Tariq took off running, and ultimately he hid behind a bush. When the police officers grabbed him, they kept asking him, so why are you running? Why are you running? To which Tariq replied, because you are chasing me, right? So this is a classic exchange between children of color and police in America. A child sees the police. The child is convinced that the police are looking at him. He gets nervous that he's about to be accused of something that he didn't do. The child's nervousness makes him look like he did something that he didn't do. And the child then runs away. Exacerbating the situation, the police then use the child's running away to convince judges, prosecutors, and the like that the child was indeed suspicious. And so it's a really difficult conundrum for a child to be in. And so I want to turn back to you, Professor Ward, and help us again to understand what's happening in this scenario. And so I think, a lot of what you've already shared earlier explains why Tariq responded the way he did, the legal estrangement, the fear and the trauma. But I want us to focus, if you will, on this phenomena of stereotype threat as a way to explain what might have been happening with Tariq, why he might have hesitated in his walk. So can you tell us, what that is and how it manifests in children like Tariq?
Sure. As you said, a lot of what we've just talked about is salient here. And so I want to just maybe begin by stressing that we should understand these mechanisms as compounding rather than kind of alternating or competing, or they are interactive. But the concept of stereotype threat comes out of cognitive psychological research and basically emphasizes that that we become taxed cognitively by awareness of stereotypes, and our effort to avoid confirming stereotypes, ironically, contributes to an underperformance cognitively that can contribute, in fact, to an adverse outcome that may be consistent with a stereotype. Some of the earliest work on this looked at the environment of high stakes testing, for example, where this anxiety around performing poorly on a test was cognitively taxing for students of color who had internalized ideas subconsciously, not necessarily consciously, but implicitly, that they are less likely to do well, let's say, on an algebra test, and that anxiety is cognitively taxing in a way that, in fact, results in an underperforming on the test. And so, in this scenario, you have a situation where stereotype threat can be a part of what is entrapping a child. That is part of what is increasing the likelihood that this child comes to the attention of the criminal legal system, is arrested, perhaps, and then so on. And here, the situational predicament potentially causes the young person to fear that they're being perceived as a criminal on the basis of their race, and perhaps other characteristics, class, age, and so on. And as a way of compensating for those fears, begin to act in ways that are odd, are not what they would normally do. They are, in a sense, overthinking things. And instead of remaining calm, because they cannot remain calm in that moment, given what we've talked about in terms of this, the backdrop of legal and racial socialization, given stereotype threat, they're more likely to be perceived as suspicious. And the number of studies have demonstrated this in a lot of different institutional contexts, but including in relation to encounters with police, where Blacks but not whites report concerns that police officers stereotype them as criminals because of their race. So we know from the research that there is awareness of this stereotype that could contribute to stereotype threat. And this causes some to engage in self-regulatory behaviors that actually make them look suspicious. I know this, I know, for example, I could share just quickly an example from my own. I mentioned growing up in Los Angeles in the 80s, when there were serious problems of crime and drugs and gangs and so on, and we being routinely harassed by police. But it was so normalized that me and my friends and my brother, when we were together in our car, would always announce that we'd seen a police car somewhere nearby. It would be a broadcast inside the car, police, 3:00, and we'd all start doing things like, if our hat was on backwards, we put it on straight, and we'd put our seatbelts on. And, in our minds as adolescents, young and high school age kids, our minds, we were lessening the odds of a police encounter that we feared, at the very least was going to be inconvenient, but could also become quite more serious. But now I know that we were probably in many of those instances engaging in behaviors that increased our vulnerability to a police encounter, because we were cognitively taxed by this awareness of the stereotype that would be applied to us, and engaged in this self-regulatory behavior. And it should be noted here too, in relation to the research on adolescence, that we also know that young people are not particularly good at making informed decisions. Young people misperceive risk, routinely, often underestimate risk, overestimate their ability to avoid it, are not particularly good at reasoning things out in a kind of long-term way. And so that limited cognitive capacity, coupled with the phenomena of stereotype threat, makes it highly likely that adolescents, and particularly adolescents subject to these stereotypes, are going to come into encounters with the criminal legal system.
Yeah, I mean, this intersection again of adolescence and stereotype threat, and then we could pull in that trauma. So, and when you consider all three of those, you can, if you think about Andre's scenario, Tarek's scenario, you can almost see this cognitive overload happening, right? You can imagine his mind spinning as he's walking and he sees these officers and he's thinking, so what do I do? So it's like, let me think, do I keep walking? Do I stop? Do I flip my hat around forward and backwards? I think that was a great example of that. There's even one study on stereotype threat that I read where they talk about, Black men whistle classical music when they see the police so that the police won't think that they're criminal. So it's amazing, and particularly when you intersect that with adolescence, it makes a lot of sense. Or it really helps us understand what was probably going on with Tarek and his stutter step that the police talked about. It's also worth, I want to pull in that thread, that trauma thread, just one more time, because as I was listening to you and thinking about this scenario, it also reminds me of our natural fight, flight, or freeze response, right? So the body's natural reaction for just a couple of seconds, the brain freezes while they face the fear, while Tarek faces that fear and tries to figure out what to do. And what's so fascinating about sort of these trauma response or fight, flight, and freeze responses is that if tying in what you talked about earlier with the historical trauma, if Tarek has had prior negative experiences with the police or has heard about prior negative experiences with the police, then he is likely to experience just the sight of the officer as a triggering moment, as a triggering traumatic moment, even if those officers actually weren't even looking at him. So we don't even know. But I think your description of this cognitive overload or the overthinking that is happening. And then, as we think then, if we understand this notion of stereotype threat and adolescence and trauma, and think about how it all ties to the law, I think really this is all about reasonable, articulable suspicion, right? And that if we, as we accept this research and as we learn more about what's happening in the minds of young people, we really need to recalibrate what reasonable, articulable suspicion looks like and how it should be analyzed by judges and others. And so, for example, the stutter step, is that indeed reasonable, articulable suspicion? Flight from the police, when an officer, Tarek, takes off running, is that indeed reasonable, articulable suspicion? Is it appropriate to view that as evidence of consciousness of guilt or evidence of fear, evidence of adolescence, evidence of stereotype threat? And so we've got to be more careful. And again, it's worth noting that some judges, federal and state courts, have begun again to acknowledge the realities of race and race and adolescence in this sort of analysis of reasonable, articulable suspicion, such as flight. And again, our colleagues from the National Juvenile Defender Center, can reference those in the chat. Commonwealth versus Warren being one of the leading cases, or one of the forerunning cases that acknowledge that, that young Black folks run from the police for all sorts of innocent reasons, including fear of the police. So I want to continue to unpack Tarek's scenario a little bit more. And I want to talk more about how race impacts the officer's perceptions and interpretations of Tarek's behavior. All right, so we know there is a growing body of research on the ways in which racial bias impacts perceptions of Black youth. You've mentioned that, Ebony has mentioned that earlier in the introduction. So can we talk for a second, if you can help us here again, Professor Ward, talk about the ways in which racial bias impacts police perceptions of Black youth and other authority figures?
Sure. Yeah, I think there's, obviously we're talking in general terms and not about the specifics of this scenario and the officers involved. But all that being said, as I started out my remarks, I mentioned that the problem of recognition has been fundamental to the racial politics of youth justice since the inception of the American juvenile justice. And I talked about recognition in terms of, recognition of humanity, and recognition with respect to the idea of the child is a part of that. When we're talking about youth justice, and recognition with respect to democratic standing, political standings, standing within the context of, say, the social contract, and including things like the Bill of Rights and constitutional protections around due process and so forth. And what's been interesting to me about recent research is how clear it is that even though we claim in the modern era, many of us claim to have sort of moved away from this sort of differential orientation towards different kinds of human bodies, scaling bodies in different ways as more and less human. So the idea of color blindness, for example, people have been adamant that they don't see race, but we know from systematic social science research that in fact we continue to make these distinctions, and that police are among those who make the distinctions. And also one piece of research I'm thinking of in particular here is by Phil Goff and colleagues that looks at the adultification of children, or in other words, the routine overestimation of the age of a young person when that person is Black. That study found that, I believe, among the general public, respondents perceived African Americans, particularly when they were primed. These are experiments, and so when they're primed with information that labels the person a felon, a youth, a suspect, a youth suspect suspected of a felony, that general public participants overestimate the person's age, the African American youth's age, by 4.5 years. They believe they're 4.5 years older than they actually are. Among law enforcement participants in the same study, looking at African American youth primed with the information that they are a suspect in a felony, their overestimation of age is slightly higher, 4.6 years older. Now, I think the key thing to emphasize here is that the prime, not only of race, but of criminal involvement, is key to this, to the extent of the age overestimation in this study. And so if you are going into an interaction looking, if you're a law enforcement figure and you are consciously or subconsciously thinking that a crime may have occurred, or this figure may be a suspect in a crime, the study suggests that you are even more likely in that scenario to overestimate their age, to see them as an adult, and thus to, as was the case in the 19th century and for throughout the period of Jim Crow juvenile justice, to withhold from Black youth recognition of their childhood and the things that go with that. Recognition of immaturity, of diminished criminal culpability, of vulnerability. You're less likely to approach that person from a care perspective rather than an enforcement perspective if you perceive them to be an adult rather than a child. This study also showed that both the general public and law enforcement participants perceive Black felony youth suspects as more culpable than either white felony suspects or Latino felony suspects. So all felony suspects, but the subconscious biases are such that the respondents are disinclined to extend to Black youth the kind of notion of diminished criminal responsibility to the extent they are willing to extend that to white and Latino youth who are also criminal felony suspects. This has also been shown, these relationships have also been shown in the context of gender and race interactions and the erasure of Black girls' childhood. And so as a sort of interactive compounding problem of simultaneous race and gender-based discriminations with profound consequences, for these youth. I'm curious, there's been a lot of research in the implicit bias context, and I see someone in the Q&A has asked, how do we confront these implicit biases? I'm curious to know how legal advocates and the courts generally have responded to this growing body of evidence of implicit bias, particularly in the context of the juvenile justice system.
Yeah, I think that's the right question. And I've been thinking a lot about that in, my own, research and writing and training. And one of the things that I really think we all have to insist upon is a more nuanced explanation, for example, as we think about implicit racial bias, a more nuanced explanation from police officers for why they stopped an individual. So, that's just one example. But in this Fourth Amendment context, as we're thinking about Tariq, and we're thinking about whether or not in that factual scenario that Tariq's behavior of hesitating as he walked, of the stutter step, which is very commonly seen in police reports across the country, is a fair consideration of reasonable articulable suspicion. And so when we think about the ways in which implicit racial bias distorts the officer's perception of Tariq's reaction, we as judges and lawyers, have to demand a more precise, nuanced articulation for what was the reasonable articulable suspicion that the officers had in that moment to believe that Tariq was engaged in some criminal activity. I mean, it's a Saturday morning at 10 a.m. and he's just walking. Lo and behold, right? And then the officer begins to follow him and he takes off running. This is what children do, right? So I think that's, for me, is one of the things that I have really been trying to advance. Also making sure that all of us understand the breadth and the scope of implicit bias. And I like what your word is, the ways in which race and criminality intersect, such that when a child is perceived to be involved in some felony, right? The officer is on routine patrol in a high crime neighborhood. His presumption is that the Black child that he sees is older than they are. And so that we have to take that into account when we think about things like reasonable articulable suspicion. The other things I talk about in terms of how do we account for implicit bias is that I remind folks that Again, this is this notion of equity of rights, equal protection of the rights under the Fourth Amendment, that we have to remember that when an officer walks into a convenience store, we have to remember that implicit bias shapes where his attention is drawn. So the attention is automatically drawn to the Black person in the room, right? And not only is it automatically drawn to the Black person in the room or the Latino person in the room, but it's drawn to certain parts of the body, the hands, the waist area, right? Such that movements, nervousness, natural nervousness or natural adolescent jitteriness in a moment like that gets quickly, rapidly interpreted as suspicious, right?
Automatically.
Automatically. Yeah.
Outside of our conscious awareness.
Exactly.
One of the other studies that's interesting here, that relate to your example in the store, I can't remember if it was by Geoff et al. Or Eberhard or one of the other groups from that team of scientists, but showed very compelling evidence that visual processing of objects and the extent to which they are crime relevant is deeply connected to whether you are conscious of race in the moment. So literally being able to see something you think is a gun or make out an object as a gun, for example, or a knife or other kind of crime-related object increases dramatically as a physiological phenomenon. If once a racial prime is activated where you are also thinking about Black people. And it's important. It's important here to remember the inverse as well. So the difficulty of seeing crime. I mean, I was really struck by this, for example, on January 6th with the siege of the Capitol, and the paralysis of it seemed to me as a viewer of many of the law enforcement figures at the Capitol, who seemed to just be unable to act. And I thought about that study. I thought about some of those studies because I think part of what's happening there is the inability to process this information as crime requiring, or as a threat requiring vigilant response, because it does not align with the wiring of our brains that has made us particularly hypervigilant and punitively oriented when we are encountered with offending by people of color. And another place you see this, and I see one of the questions, what does it dismantled structural racism look like? I think it's a great question. I hope we can talk more about it. But I don't know if it's still out there, but there was this fascinating Twitter feed called Criming While White, where you had all these, mostly young, I think, or people talking about their experiences of white youth engaged in crime and how how police and others responded to them. One said, I was drunk at a party and got in a fight. I punched a police officer in the head, and he took me home to my parents. I mean, I think we can learn from those kinds of, from that truth telling. We need more of that truth telling and bearing witness to the reality of the unearned advantages, rooted in unearned disadvantages in our criminal legal system. If I could mention one other, because we're talking about running from police, I think just to convey the absurdity of our and depth of our predicament. I was listening to I think it was a documentary or something about the talk that New York Times put out a few years ago, where one family shared that their son, African-American, who happened to be, tall as a boy, as an adolescent, also, so he looked older, they said, but he also loved police. He was fascinated by police. And anytime there was like a police car going by with a siren, or there was he would run to the scene. And they had to tell him as he was older that is extremely dangerous.
Yeah.
Unfortunately, your excitement, that society is likely to misinterpret your interest in policing in such a way that may lead to you being seriously injured or even killed. I just thought, it was a really interesting example of the burden of self and collective regulation in a hostile environment, in an environment of such profound legal estrangement. And I think this isn't a direct answer to the question about what it looks like to dismantle it, but as you've said a number of times, I think we have to focus on that question. We have to focus on what are the options we have, and which of these is going to contribute most to dismantling these problems of structural racism, which, first of all, I think we need much more understanding of in the general population. But which of these, in other words, if it was up to me, rather than kind of rehashing or doubling down on the rehabilitative ideal, what does a reparative ideal look like, and how do we institutionalize that? Not only in the court systems, but in other institutional contexts, schools and health and so on.
Yeah, no, I think all of those are great. Again, you just raised so many threads that would be fascinating to pull on. Let me just hit a couple. One, you talked about that hashtag, that Twitter feed, crimming while white. I should just note, as Ebony said in the introduction, I have a book coming out, The Rage of Innocence: How America Criminalizes Black Adolescents. And I also was so fascinated by that Twitter thread. You'll see that is in the book. I actually draw out some of the examples and use that as a framework to talk about the ways in which we just don't see the criminality, or we're willing to accept and tolerate, maybe that's the better way to say it, the normal adolescent. So I just wanted to note that's a place to read more about that. The other thing I wanted to pick up on, one of the threads you talked about, was the ways in which implicit bias works in the interpretation of innocuous objects, right? In that study you talked about, what I wanted to add to that was that there is an additional research beyond what Jennifer Eberhard and Phil Goff and some have done by, I believe his name is Todd Thiem, but in your implicit racial bias annotated bibliography, which we have now put in the chat, you will see a study where it really demonstrates just how strong the cognitive link is, or the cognitive mislink, if I can make that word up, is between Blackness and criminality, because it shows that in one study in which the participants were shown a series of innocuous objects, including a baby's rattle, a toy rattle, that the participants were more likely to misinterpret that baby's rattle as a gun, even when they had been associated, even when that image had been associated with a baby's face. Or a child's face as young as 5 years old. So this notions, right? You talked about this recognitions of childhood. So these notions of childhood, Western commitment to childhood care and protection are out the window when we think about race and crime, and that a 5-year-old is, believed to be carrying a gun instead of a baby's rattle. Is pretty powerful. Shows you how powerful that effect is, especially for the conversation that we're having. Let me answer. Let's try to see if we can hit a couple of the questions that were in the Q&A. One of the questions I think ties back to some of this suggestion about looking for a more precise and nuanced answer from from police officers about what constitutes reasonable articulable suspicion. And one judge asked the question, well, are we as judges limited to what the advocates offer to us in their facts, their cross and direct examination, and in their arguments and in their pleadings? And my position to you is absolutely not. Within limits, of course, right? But that you as fact finder in a suppression hearing, as a judge, certainly have that opportunity to ask of the officer some additional questions, right? Really requiring them to dig deeper with greater nuance on what precisely was it that led them to believe that the young person was suspicious or engaged in a crime. And it's not enough, that there was just a stutter step. It's not enough that it was just a high crime area. It's not enough that they just appeared nervous. It's not enough that they were just, appeared to be engaging in furtive gestures. I often say, who gets to decide whether or not something is a furtive gesture? Who gets to decide whether somebody is nervous or not, and whether that nervousness is nefarious or not? And it's, we've got to be careful because we all have our own implicit biases. Another question that was asked a couple of times is, were any of my arguments successful in Andre's case and Tarik's case? And let me just say, one of the reasons that we gave you those sample cases is to demonstrate that indeed, across the country, slowly, both state and federal courts are beginning to understand these arguments. So the answer is yes, I have been successful. Finally, over years, it's a slow progression. In the same way, I should remind us all that we didn't understand how important adolescent brain development was and adolescent psychology was to the law. But now we do, even more than ever before. And it's the same thing with race. The more we have these empirical studies and the more we have conversations with folks like, Professor Ward about the historical consequences and the historical significance, that it is then that we begin to understand how race intersects with how race intersects with these critical legal questions. And so, yes, the answer is we are winning some of these. We are able to successfully convince our fact finders that flight isn't always consciousness of guilt, especially among children of color. So, okay. What I want to do is I want to do another scenario. And this additional scenario is going to bring us back to some of the trauma questions and introduce us to a new piece, which is the you've started to talk about it a bit, but it really presses on the intergenerational trauma and what that means and the history specifically of the juvenile legal system. So let me tell you about Jamal. So Jamal, on one spring day, again in Washington, D.C., stops by to visit his cousin who lived at an apartment in the city. Just as he was leaving, Jamal noticed that a police car drove up slowly behind him and stopped in the middle of the road. Okay, the police car was carrying 3 uniformed officers, 2 of whom were white and 1 of whom was black. One of the white officers in full uniform with his gun visible on his waist got out of the car and began walking rapidly in Jamal's direction. The officer yelled out, "Hey, sir, may I talk to you real quick? Did you just come out of that building?" Jamal stopped. He turned around to face the officer and he said, "Yes, I was just trying to call my cousin." The officer continued to ask questions like, "Do you live there? Let me check you out. Do you have any weapons on you? Do you think I could pat you down real quickly?" And Jamal, angered by these persistent questions, turns around to leave. The officer grabs Jamal's jacket, pulls him back, tackles him to the ground, and another officer joins in to hold Jamal's face down in the dirt with his knee in his back. When they asked Jamal, "So why are you running?" Jamal says, "Well, because every time I get locked up for nothing." And so the banter between Jamal and Andre continued like that for quite some time. Jamal repeatedly asked the officers to pick him up from the ground and to get him out of the dirt, explicitly asked, "Get me out of the dirt." Every time Jamal himself tried to scoot himself up and sit on the curb, the officer grabbed him by his ankles and yanked him back into the dirt. At one point, Jamal became visibly agitated and yells out, "You all do you all do Black people wrong. You just do Black people wrong." And other people from the neighborhood came out and they watched. And so when, again, this was a young man that I represented, and when we interviewed him after his arrest, it was clear that everything in this case, from his point of view, was explained by race. Race explained why the officers were always in his neighborhood harassing him and searching him, whether he had done something wrong or not. It's explained for him, race explained for him why the officers always assumed the worst about him, why he had no choice but to assume the worst about the officers. It explained why the officers kept him in the dirt even after he had been handcuffed. It explained why the neighbors came out to watch and to make sure everything was fair, and on and on. And so it was clear that Jamal's understanding of who he was and what it meant to be a Black teenager in America had been shaped by many moments like this, many moments he had either witnessed or experienced himself. And so his very identity, right? His very identity was developed sort of in conversation with and about police officers who were stopping him. And so, I want to again engage, you, Professor Ward, Jamal and all of the young men, to be quite frank, that we have been talking about had multiple interactions with the juvenile legal system after their arrest. And in some of those situations, indeed, they were engaged in criminal conduct. But it's important for us to recognize that Andre, Tariq, and Jamal all were suffering from a trauma that was following them their entire life, growing out of encounters just like the one that I have described here. But we also know that the trauma these boys have experienced did not start with any one individual traumatic encounter. And so I think it's really helpful if you could tell us a bit more about intergenerational trauma, right? Intergenerational trauma that Jamal is likely experienced. And I think that builds upon, some of what you've already talked about, but there's something more in this sort of legacy of racial violence that I'd love to hear from you.
Yeah, thank you for the question. In the Black Child Savers, I became really interested in working on that book. It really changed the way I understood the nature of racialized violence and structural violence. And in particular, I had this sort of, I think, almost episodic orientation, like racial injustice is something that happens in a particular moment. But what was striking to me about that story as I was getting into it was how structural violence was casting into the future. Structural violence affecting most immediately Black youth and other youth of color was casting into the future collective social, economic, and political disadvantages. This is why Black women began organizing in the 1890s to dismantle the Jim Crow juvenile justice system, because they recognized it they called it a genocidal institution that was killing the seeds of a people and disadvantaging future generations of African Americans with regards to participation in the economy, participation in politics, and so on. And so they took it upon themselves initially to create their own rehabilitative institutions and ultimately to formally integrate the juvenile justice system and so on. And I'll say maybe a bit more about that in a moment. But following on that work, at some point I learned also about this, what at the time was a relatively small body of work showing that histories of racial violence predict contemporary patterns of conflict, violence, and inequality. And this is where I've learned a lot more about intergenerational trauma. But just to connect the dots for a moment, the Black Child Savers recognized that the traumatization of Black children in their own time was gonna essentially become a kind of historical trauma that would shape the circumstances and life prospects of future generations of African Americans. So that's one way just of thinking about intergenerational trauma, is this passing on over generations of harm. And what we've been learning. So in that context, I became really interested in the time scale, the temporal arc of racialized violence and how it works over time and what the implications are for mitigation. And so I began looking closely at this evidence that histories of lynching in particular, lynching has been focused on in part because it's one of the few well-documented examples of racialized violence historically compared to other forms. And study after study has demonstrated its enduring effect, essentially that we socially embody and reproduce historical racial violence. And most of this research is at the county level. So in counties, for example, with pronounced histories of enslavement or lynching, contemporary odds of conflict and violence and inequality are heightened. I'll give you, I mentioned one example in Black victim homicide, but I want to talk about another one that's more directly related to the juvenile justice system and this particular vignette. One of our recent studies showed that every additional lynching in the history of a county increases pretty dramatically the odds that a child, and especially a young African-American child, will be corporally punished in schools today. 19 US states continue to permit the corporal punishment of children in schools, even though the United Nations regards this as a human rights violation. Most professional associations, judges, child welfare specialists, and so on and so forth, have condemned the practice in light of the evidence that corporal punishment in schools has adverse mental health impacts, socializes children to see violence as a way of resolving disputes, contributes to school dropout and the likelihood of involvement in the criminal legal system. So we found that every additional lynching in the history of a county increases the odds for Black children by 6% that they'll be corporally punished in schools. If they go to a school in a county with a significant history of lynching, the likelihood of their being corporally punished is much greater than a counterpart in another county without that history of racialized violence. Now, the reason I want to share this study is because I think it presents a fascinating intergenerational trauma story. And to be clear, for the record, we aren't able to tell from the data exactly the mechanisms at work here, but what we believe to be at work, given other research, at least in part, we don't think this is largely a story or exclusively certainly a story of racist white school personnel beating Black children in counties with histories of lynching because they're racist. We think that there's some of that, but we think that another part of this, which gets more directly to the intergenerational trauma point, is the hypervigilance of Black parents in these communities, distinguished by historically elevated levels of racialized threat that are captured by the measure of lynching. So these are communities where, if we think about all the evidence about the legacy of lynching, where violence rates are higher, where public support for punitive crime policies are higher, where infant mortality rates are higher for Black. These are essentially microclimates of racial meaning shaped by violent histories related to race. And we think in those environments, African-American families are more likely than their counterparts in other environments to permit schools to use corporal punishment in disciplining their children because of other research. The reason we believe this is part of what's at work is because other research shows over and again that African-Americans tend to view corporal punishment as a protective mechanism, protecting Black youth from graver threats around them. So, Ta-Nehisi Coates writes about this really passionately in one of his works, where he says essentially, our parents were so worried that other people were going to kill us that they almost wanted to kill us themselves. He talks about this love combined with fear that results in can result in very severe disciplinary orientations. And we think this is extending into the school environment. Now this is an example to me of the embodiment socially of historical trauma. Namely, we talked about the estrangement, the distrust, the sense that the state will not only not protect you, but might also kill you, resulting in a hypervigilant form of behavior that affects a subsequent generation. And the effect, remember, is most evident for the youngest children in schools. We can talk more about why that is. But this is a legacy that is being carried forward, passed on, and contributing to the likelihood of a number of adverse outcomes for the contemporary young person who is subject to this alienating experience in the school context, which might lead to their failing to complete school and so forth, which we know increases the likelihood of involvement in the criminal legal system. Now, part of why I want to share this story is because, this isn't something that Andre or Tariq or Jamal would necessarily be aware of. It would not be discussed even per se. It is part of, unfortunately, to many of our communities, it is part of the social milieu. This forget the judge who referred to this as a rotten social, this rotten social background that gives rise to additional traumatic encounters and the additional stress load and so forth that shapes the life circumstances and prospects of a young person like Jamal. And now I want to end this point by noting, someone asked in the chat, what does dismantling look like? There is right now pending federal legislation to abolish corporal punishment in schools. I think that kind of policy is something that can contribute in a substantive way to lessening essentially the yoke of the past, the extent to which the past continues to hang over and haunt us, and to shape our current and future prospects. And to the extent we can move away, and I think we are, I think this conversation is an example of that, and we've seen a number of them in the wake of the Black Lives Matter and reckoning with structural racism. To the extent we can move away from this idea that all of that is behind us, that this is the distant past, irrelevant to the present, and instead commit to grappling with the ways we embody socially and reproduce the violence of the past, cognitively and behaviorally and so forth. I think we are far more likely to achieve something that we might call transformative racial justice. And just as a plug, colleagues and I here at Washington University recently published a special issue of the Annals of the American Academy of Political and Social Science, where we bring together scholars from a range of disciplines, public health and biological anthropology and history and sociology and others, to assess the state of the science on legacies of racial violence, and to reflect on the implications of this work for policy and reparative practice.
Yeah, so I think that's a great place for us to sort of jump into questions. And so you picked up one of the most important questions, was that question that was asked about, so what are the examples of ways in which we can dismantle structural racism? I think your answer was spot on. You gave a legislative example of banning corporal punishment. I think it's worth just pausing for a second to, we've been talking about structural racism, and I think we all know, what it is, but it's worth sort of naming it. Structural racism is the ways in which public policies, institutional practices, cultural representations, or recognitions, as you call them, and other norms in our society work together and to reinforce and perpetuate inequities in society. So when that, for me, is important when I think about, well, how do we begin to dismantle? And I mean, look, it's one thing at a time, right? So what are those policies? What are those institutional practices that we can dismantle? And as judges, because I mean, I think so I want to say a word about judicial leadership and about legislative and policy reform, because I think that's important in this space. But I also want to say that even in individual cases, I said earlier, structural racism occurs in the ways in which we interpret the laws and the ways in which we apply the laws. And so even in individual cases, we are working to dismantle structural racism by really giving true meaning and application to those constitutional protections by accounting for race. But then separate and apart from that, as you just talked about, what are the policy reforms? And so, it's important to think about ways in which we can shrink the size of the juvenile legal system. So for the prosecutors who are watching this, this webinar, thinking about ways in which you're charging decisions. You are the gatekeepers on the front end of the juvenile court. So what ways in which do you have control? Judges who have power to dismiss, statutory power, some inherent powers to dismiss, adjudicatory outcomes, decisions that you make, suppression decisions, all of those work to shrink the juvenile legal system. Other ways is to, as a judge, working in that leadership capacity to identify diversion programs. And I actually, I'm almost afraid to say diversion programs because we need to do, school-based reform before we ever get to diversion. But at a minimum, shrinking that front door, closing that front door to racial disparities through increased diversion programs. In my mind, judicial leadership also, even though you can't lobby, you can testify, right? Like you can give factual examples from your caseload, abiding by confidentiality, to legislative bodies who are considering questions like no consent searches. Like they should just be abolished. They should be abolished for all children, and particularly children of color, that no child really has the cognitive capacity, experience, and wherewithal to make the kinds of decisions on the street about consent to search. So there are legislative movements across the country to ban consent searches. There are legislative movements across the country to prohibit interrogation of young people and young people of, and I would add to this how important that is for young people of color who are dealing with stereotype, threat, and cognitive overload, but prohibiting interrogation of young people without lawyers. I could, really go on and on. I'll give one more example. I'm going to definitely kick it back to Professor Ward if you want to answer this, but I see a question here. What are your opinions? What are our opinions about school resource officers in the public school space? I think that's another piece of dismantling structural racism, and that judges and other court stakeholders can weigh in on, even if factually, even if it's not lobbying. But my opinion, I think grounded in the research and not just my opinion, but it's my opinion based on observation and research, is that we forget just how traumatic just the police presence is in school spaces for Black and Brown children. And again, for those of you who are interested in this, reading about this in my book, The Rage of Innocence, I have, a couple of chapters that really grapple at this, that the evolution of school resource officers in the school space is a part of that backlash after Brown versus Board of Education. right? That's when, we get school resource officers. And so this notion that, you've been talking, Professor Ward, about the historical evolution of all of that. There's also that through line, that the introduction of school resource officers was all about control and resisting the integration of schools. Contrary to what was put out in public about school safety and about Columbine, that whole narrative has to be rewritten, right? And that also, notwithstanding, the fact that Columbine and other high-profile school shootings took place in white, wealthy, middle-class suburbs, you see the population, or the predominant population of school resource officers in Black and Latin in schools with a high population of Black and Latinx schools. So that tells you everything we need to know about, or a lot of what we need to know about race. And then you move beyond that to talk about the ways in which that police officers in schools don't make Black and brown children feel safer. In fact, it makes them feel less safe. And in reality, it makes them less safe because of the things that Professor Ward talked about, both with corporal punishment, but all of the examples, high-profile examples we've seen of police, violence in schools. And look, I know many of you are saying, but that's, a small percentage of police officers. Well, whether it's a small percentage or a large percentage of it, one of the things that we are saying is that I'm trying to use your words, Professor Ward, the historical memory, right, is there for every child to see. So even one bad example of a child being body slammed by a police officer or thrown down a stairs, or something like that, has a traumatic effect on the psychological well-being, on the subsequent, engagement in delinquent behaviors, negative school climate, distrust of school resource officers that transfers to school teachers and other administrators, this legal estrangement that we're talking about. So I think, we've got to reimagine school safety. And again, it's this false binary that, the absence, the police-free schools movement means, school will run amok, the children will run amok, and it's just not true. If we replace that, part of this dismantling structural racism is replacing those structures, right? Those police and traditional law enforcement structures with mental health providers, right? And then I'm going to kick to you. One of the questions that came in was, what's the difference between restorative rather than rehabilitative justice? And I think that's a nice segue for us for two things. If you will allow me, is to pose two questions. One, answering that question. What is, in your mind, the difference between restorative and rehabilitative justice? But I think you might be able to tie that in to what I have seen, and I haven't seen enough research on this, so tell me if I'm wrong, but that the mere involvement in the juvenile legal system, separate and apart from policing, we've focused a lot on policing, but separate and apart from policing, that the introduction, right, the cumulative and compounding effect of moving the child from arrest into the juvenile legal system and all that flows therefrom is traumatic in and of itself. And so if you could say more about that, and maybe something about the restorative versus rehabilitative responses.
Right, yeah, the question was about punitive versus reparative or restorative, I think. I guess I want to say one thing about school resource officers related to that, which is I think we have to think about school resource officers as part of this continuum of mechanisms we use to presumably support educational missions of schools. And there's a whole continuum of efforts, which include high quality, well-paid teachers who have tenure in the school and experience. There's, things like student to teacher ratios and technology and adequate recreation and quality food, nutrition, And so I think when we're thinking about school resource officers, it has to be in the context of this continuum. And there is also in that continuum are things like, unfortunately, drug sniffing dogs and metal detectors. and cameras. And we did a study recently where we looked at, some colleagues and I looked at how race and class relate to the distribution of these security measures in schools. And what we found was that race and class, especially race and class interactive, were really strong predictors, but really at early grade levels of the more exclusionary forms of school security. That is, measures that are designed to detect offending and thus to trigger consequences for offending. So like drug sniffing dogs and metal detectors. Those mechanisms were far more likely to exist at middle school levels and even elementary school levels when the predominant student body was predominantly poor and students of color. And the measures we found, school resource officers among them, tended to be more ubiquitous. I mean, this is where we are in this country, but tended to be more ubiquitous at higher grade levels. Now, this was a study of public schools. It's not including private, institute. So there are limitations to the data that the Department of Education collects. But I want to flag that because it's saying to us that early in the educational experience, poor kids and kids of color who are poor in particular are much more exposed to this school that's like a prison than are their counterparts who are not poor and white. And some of the research on race and education, one of the most interesting findings to me in that work is that kids of color are at early grade levels just as excited about school, just as invested in school as their white counterparts, irrespective of class. And that drops off a cliff once you get into the upper elementary grade levels and approach middle school. And it's an evidence of this estrangement that is occurring in our school systems for one subset of children and not another. So I think and then to more generally respond to the question about what reparative approaches look like, I'll go back to this continuum and just ask you to consider that there are really, there are sort of two poles in this continuum of sanctions available to us. At one end, we might call them exclusionary sanctions that are really designed to weaken or break entirely social ties. Incarceration is a good example of that. It is not designed to strengthen your ties to society. It is designed to literally remove you from society. And the longer term incarceration, the more punitive the terms of incarceration and so on, solitary confinement and all that, life and so forth, are especially extreme. We have to talk about in this context deportation. This is something that charging decisions in this period of punitive immigration control, charging decisions can have very serious consequences for whether you can continue to exist in this country. And that is an extreme exclusionary sanction. At the other end of the continuum are what I will call inclusionary sanctions. Sanctions that are designed to protect and strengthen social ties. And that's where things like diversion, mental health services, treatment of things like addiction, skill development, opportunities, responses. And I hesitate to use the word sanctions even because of our punitive political culture. It's hard to even render that in some way other than exclusionary. But consequences that are designed to deepen social ties, to strengthen present and future potential to thrive in the society are at the other end of this continuum. And so what I'm referring to as reparative or restorative approaches are approaches on that inclusionary end of the spectrum. And just to go back to the legislation around corporal punishment, the legislation would require that schools replace corporal punishment with inclusionary sanctions that keep the child in the school, that address the root causes of their behavioral problems, for example, and that equips schools to do that. Schools are and teachers are not necessarily just in the same way that police and courts and so forth, social probation officers are not necessarily equipped well to pivot in that way, but the legislation would provide, in theory, some support for doing that. I think, if I could say one last thing about this dismantling, what does it look like? I want to be clear that I don't think of this as like a switch. We're not going to just like flip a switch and structural racism is off. It is so deeply woven into the fabric of our society. Someone mentioned Eduardo Bonilla Silva in the Q&A in relation to colorblind racism. He was my first advisor in graduate school at Michigan. And so I learned a lot about structural racism from him. And the basic point about structural racism is that it is understanding racism not as this aberrant, deviant psychological phenomena, this kind of hang up with race that some people have who are racist and have these racist ideas, but rather fundamental to how our society is organized in ways that Professor Henning, you mentioned, our normative structures, our institutional structures. The structural racism has existed to such a profound extent and for so long now that sociologists pointed out a while ago that you no longer need active discrimination to maintain racial inequality. The history of hoarding opportunity through things like redlining, the prevention of the accumulation of wealth, disenfranchisement, and so on, those have locked in advantages rooted in unearned advantages to such an extent that we don't need active kind of extreme racism to perpetuate these things. And it is a really vexing question. How do we chip away at this edifice of structural racism, and what do we replace it with? I think the calls to defund policing are fundamentally calls to dismantle the systems of structural racism and build something in their place. And it's a shorthand way of describing this more complex idea. And I know that I said it was going to be the last thing, and that's never true for me. But I do want to just speak, because I meant to say also to come back to what it looks like to what this looks like in the context of juvenile justice. I'm really swayed by these calls to reimagine, and reimagine is not the right word, but to embrace the actually vast footprint of the youth justice systems in our society, and to invest in those parts of the system that are particularly critical to the well-being of young people, like prenatal care and other kinds of support for women who are pregnant, and for young parents, things like high quality access to high quality daycare, addressing the commodification of high quality daycare, access to high quality after school programs, and so forth. So before we even get to issues of diversion, before we even get to courts, we have a robust system of protecting young people and communities in terms of their the realization of their full potential.
Yeah. So thank you so much. I think it's a wonderful way to end with this, how do we dismantle structural racism? I think you've sort of begun to give, I think throughout the 2 hours, we've each identified at least one or two ways in which each of us as a judge in individual cases, as a systemic partner with other institutions like schools, like legislative bodies, there is a role for all of us to play in dismantling structural racism. So thank you for that. Thank you again, Ebony Howard, for allowing us to participate in this conversation. And so we're going to kick it back to you to close us out. Thank you so much for this conversation.
Cool. Thank you, Professor Henning. Thank you, Professor Ward. You all are amazing and wonderful as usual. We so appreciate you being willing to lend your time to have this conversation with us, to lend your energy and your service. We so appreciate everything that you are and that you do. For our audience, I really hope that this time was valuable for you. For our juvenile court judges that are in attendance, I really hope that you've gained a deeper understanding of your role in the lives of the youth that come before you. Juvenile court judges are so critical to dismantling the system of racism that hurts our kids. And it's through your actions that we can course correct the negative impact that the system has on young people. You truly are the key. And it's for that reason why NJDC, working with the National Council of Juvenile and Family Court Judges, are launching the Judicial Racial Justice Network. It's a 6-month program for It's a 6-month program for juvenile court judges who are willing and wanting to explore the impact of historic racism on the juvenile legal system, and also to develop strategies to address those problems that hurt our young people. We are going to drop the link to the application in the chat today. And for those of you all who registered for the event, we'll be sending you a link. The ultimate goal of the program is to create an action plan that you can take back to your jurisdiction and put in concrete terms so that you can help young people. NJDC would like to thank FCJ for partnering with us on this project. We so value your time and your energy and your partnership, and we cannot ask for better partners. We'd also like to thank the State Justice Institute for the grant that made this program possible. Lastly, thank you all so much for joining Reconsidering Decision-Making in the Juvenile Court System through the lens of our racial history. We appreciate your time and attention. Have a wonderful evening.
Yeah.